San Francisco, AP, another appeals court, another defeat for the Trump administration. The San Francisco-based 9th U.S. Circuit Court of Appeals on Monday refused to reinstate President Donald Trump and APO's executive order banning travelers from 6 mostly Muslim countries. A 3-judge panel said the administration failed to show that blocking citizens from Iran, Libya, Somalia, Sudan, Syria, and Yemen was needed to protect the U.S. The court also found that the PRP, SIDE, and APO's order ran afoul of an immigration law that prohibits discrimination on the basis of nationality. Another federal appeals court, the Virginia-based 4th Circuit, last month also refused to reinstate the travel ban, a decision Trump has already appealed to the Supreme Court. HERE and APO's look at how the rulings compare and what might come next. Critics of the ban have asserted that the PRP, SIDE, and APO's order was motivated by anti-Muslim sentiment in violation of the CO and STITUTION and APO's separation of church and state. The 4th CIRCUIT and APO's ruling took that question head-on, agreeing that the ban officially disfavored Islam as evidenced by Trump and APO's campaign statements calling for a total and complete shutdown on Muslims entering the U.S. and was thus unconstitutional. But the 9th Circuit sidestepped that question, saying they did and APO's need to answer it because the legality of the travel ban could be decided on narrower grounds. It's violated immigration law. While the president has broad authority over immigration, the judges said, to invoke that authority in this case, Trump would have to show the entry of citizens from the 6 countries would harm the U.S. He made no such showing, they said. National security is not an APO's talismanic INCANTATION and APO's that, once invoked, can support any and all exercise of executive power, the judges wrote. By avoiding the question of Trump and APO's motive for banning the travelers, the 9th Circuit avoided a thorny issue about whether courts should consider the PRP, SIDE, and APO's campaign trail statements. The 9th Circuit, however,